and welcome to Legal Basics with Sairolawglobal. My name is Sian. On this channel, we help you to demystify complicated legal concepts. Today, we are going to talk about a sale agreement. At whatever point in our lives, we may need to acquire or to sell property. Now, it is very advisable that when you start this journey, whether as a buyer or a seller, you start it with a legal expert. This ensures that you do not get duped by unscrupulous sellers and buyers. It also ensures that you do your correct due diligence. It also makes the process much easier and much faster, and ensures that at the end of it you have the correct documentation. So what is it that you should look out for in a sale agreement? Number one, your sale agreement must be dated. If you and your seller are present on the day that you make your sale agreement, then in that case, you will need to date your sale agreement the day that you both signed. However, sometimes the buyer and the seller are in different places or in different countries, and for some reason, they are not able to sign on the same date. When this happens, it is advisable then that you date the agreement on the date that the last person has signed it. Why do you date it on the day that the last person has signed it? Well, it is because the date on the sale agreement is the day that all the parties become bound. Remember that if an agreement has been signed by one person and not signed by the other, then it is not binding because it is not complete. A contract becomes complete when all the parties sign it. So if several people are parties to an agreement, then you're going to date it on the day that the last person has signed. The date of the agreement is also important because if you're going to stamp the agreement, then the government valuer is going to consider the date to know how much stamp duty to charge you. Remember, when an agreement goes beyond 30 days, then it starts to attract a penalty in terms of stamp duty. Secondly, you need to look at the parties. Sometimes the person you negotiate with, or the person who is a broker, or the person that helps you to get a plot, or the person that helps you to negotiate is not really the person that sells to you. So you need first of all to know for sure who is the property registered in, and then you need to know for sure how you want to acquire it. Do you want to acquire it as a person? Do you want to acquire it as a couple? Do you want to acquire it as a group? Now, if for example, if 3 people own a company, they could acquire property in their 3 joint names, which means the property will be owned by them, or they could acquire it in the name of the company. If you're buying from a seller who is a registered company, you need to also get it right. You need to understand that Sian and Sian Limited are 2 different legal people. And if you have to have an agreement that ties them to a legal obligation, then you need to ensure that you have the correct name of the party. In the event that the person that you buy from is not the person that is registered on the property, you also need to have gone through the agreement that led to this person owning the property so that you're not duped. Now, on the parties section, you need to describe the parties, that is their names. If you're dealing with a natural person, you need to capture their ID number and their PO box address. If you're dealing with a company, you need to look into the company's certificate of incorporation. This will give you the company registration number. So the third thing to look out for is the description of the property. So if you're buying property that has a ready title, you're going to capture all the description of the property in the title. The land reference number, the title number, the size of the property. However, sometimes people buy property in places that have not been adjudicated, or sometimes they buy property that is part of a bigger property that is yet to be subdivided. In that event, ensure that you describe the property as much as possible. For example, let's say that you're getting a property that is 1/4 of an acre in a title that is yet to be subdivided, but you are getting the quarter just right next to the river. it is actually important for you to describe in your agreement for sale that you're buying the property at the very corner, just right next to the river, with a beacon and a baobab tree. So how does this protect you? Because sometimes a seller will enter into different agreements for sale with different buyers. So this ensures that once the titles are out, you get the exact piece that you had negotiated. Okay? So, fourthly, you need to have a clause on the purchase price. How much have you agreed? Sometimes before you get to the process of buying property, there's a lot of negotiation. You meet a broker, they tell you no, the land is going for 5 million. You meet the seller says no problem, I can take 3.5, and you have a lot of negotiations in between. It is extremely important for you to capture what the final purchase price is. After that is captured, you need to capture how much deposit has already been paid. If deposit has already been paid, ensure that in the sale agreement, the seller acknowledges that they have received a certain amount of deposit. Now, as far as deposit goes, it is advisable that you do not pay a very big deposit until a substantive part of the seller's obligations have been fulfilled. Now, when a deposit has been paid, there should be also a clause that specifies how much balance is payable. Now, especially in situations where different people are selling, or you're buying from a family, or you're buying from a company, or you're buying from a couple, you never really know what the seller's agreement is with regards to money. So that you're safer as a buyer, ensure that the agreement says exactly which account the balance will be paid to. As a seller, ensure that the agreement says exactly which date the balance needs to have been paid. Now, also your agreement should capture the date of completion. This is the date at which both the seller and the buyer should have met their end of the deal. So for this buyer, most of the time, all they need to do is get money. So for the buyer, most of the time, their end of the deal is to just pay the balance. But for the seller, sometimes it's a very long process. If, for example, your seller is selling agricultural property, then you might need to go and get a land control board consent. If your seller is married, they have to get a consent from their spouse that says that their spouse agrees to the sale. Sometimes your seller has to go and maybe remove a caution or a caveat that has been registered against the property. So having this date, having a completion date captured on the agreement, it helps both parties to gauge whether the buyer and the seller have met their obligation under the sale agreement. The other thing that you need to look out for is the applicable law. So if both parties are from the same country, it might not be very important because it is obvious that the property and the people are in the same country, so the law of that country will apply. However, sometimes the seller and the buyer are buying property that is based in a different country. Sometimes the seller is in one country and the buyer is in another country. So it is important to note on your agreement for sale exactly which law is applicable. Then it is important to note on the agreement how notices will be served. If, for example, the completion date is already here and for some reason either the buyer is unable to get the purchase price or the seller is unable to complete whatever part of the transaction, how are they going to handle this? So it is very important to have timelines. For example, if the completion date expires on such and such a date, then the seller or the buyer will inform the other. They're going to give them another 21-day notice or 2-month notice, depending with what you agree. Now, once you have all this, it is important to have a warranty clause. A warranty clause is the clause where the seller assures the buyer that they're going to pass good title. So good title means that the property is registered correctly in the name of the seller. It means that there is no pending litigation, there is no fight, there is no court case. It means that the land is not a road reserve, it's not government property. Now, the warranty clause should always outlive the agreement. Outliving the agreement means that even once the conveyancing process is done, if something happens and the buyer gets to know that maybe for some reason this property will be acquired or the government will come for it, like what is happening in Gong Forest at this time, then the seller will indemnify the buyer. Now, lastly, you need to really pay attention to the execution. Execution means signing. On the signing part, ensure that the correct people are signing. If the buyer or the seller is a company, ensure that the people that sign are the directors or the director and the company secretary on the date that the agreement was entered. If, for example, an agreement is signed by outgoing directors and on the date of the agreement the directors were no longer in office, that alone will make the agreement to be a nullity. Now, if two people, for example, a couple, are acquiring property, ensure that both of them sign, because if both of them do not sign, again, the agreement becomes null and void. So you need to really pay attention to the execution clause and ensure that in that clause the correct parties sign. I hope that this has been very helpful to you. See you next time on this channel. Sanitize, keep social distance, and stay safe. Bye-bye. Hello and welcome to Legal Basics with Sairolawglobal. And my name is Sian. Today we're going to talk about adjoint ownership. And I will start with an example. And my example starts with a wedding. Ta-dang, here comes the bride, all dressed in white. So on this wedding day, Peter says I do to John, and they become happily ever after. So just before they become happily ever after, a person comes and gives Peter and John a bottle and says, Peter and John, put this in your living room. It's made of gold. So now, this bottle, does it belong to Peter or does it belong to John? It belongs to Peter and John. Now, can we say which part of the bottle belongs to Peter and which part belongs to John? No, because they both received the bottle together. That is exactly how adjoint ownership works. It means 2 or 3 or more people own property jointly. That means it is jointly owned, jointly possessed, jointly used, and jointly disposed. Now, if for some reason along this happily ever after, Peter feels like I do not want the bottle anymore and I need to dispose it, and John decides, no, I want to keep the bottle, is it possible for one of them to dispose their share and the other to keep it? No, because their share is not divisible. So this is exactly what happens for jointly owned property. So how do you know that a property is jointly owned? You will look at the title. On the names, it will name different people without indicating their share. That means there will be no fraction, no ratio, and no percentage. It will just read Peter and John. Sometimes parents pass their property down to their children and they want the children to hold that property together as joint owners. So in Peter and John have three children. They're going to pass it to little Peter, little John, and little Toto together. So it will read little Peter, little John, little Toto. We are not going to be able to divide this property between the 3 children because they are going to be holding it jointly. Now, in adjoint ownership, because property cannot be divided, when one of the people that are owned as the owners of the title, when one of them passes on, then this property becomes the property of the one who is alive absolutely. So that means if for some reason, I don't know who to kill in this story, whether it's Peter or John, I do not want it to be a gender issue. But let's say if Peter goes to see the Lord at the age of 89 and John is left alone, then the property is going to devolve to John? Absolutely. If Peter and John have passed this property to their 3 children jointly, little Peter, little John, and little Toto, and little Toto dies, then the property will be owned absolutely by little Peter and little John. Now, jointly owned property is good for couples. Why? Because when one of the couples dies, it means that the other couple is able, through a shorter process, to use the property and to contract with it. For example, if let's say we said we're killing Peter, so if let's say Peter has died and John needs to sell this property to take care of school fees or to take care of her health, then it is easier for this property to go through the process of survivorship. So when Peter dies, all Joan needs to do is to go to the lands registry, present her title, present all the documents pertaining to the property, and present the death certificate of Peter. So what will happen is that the registrar is going to register this property in the sole name of John. So that process is called survivorship. Survivorship is a much shorter and much easier process than the process of succession, because in succession, matters go to court and sometimes they take very long, and within that time, the people that are left behind are not able to use this property. So you find that families are stuck, yet they have real property. However, for people who are not couples and who are not a family, it is not advisable to have property jointly owned, because first of all, many people do not understand that if they are no longer here, then the property is going to go absolutely to the other people on the title. They're not going to give any share to your family. It is only going to go to the people who are named on the property. The same way, if Peter and John want to leave some of their property to their family, to their dependents, maybe to their children or to their siblings or to their parents, they need to know that if they jointly own property, if they jointly own property, then the property will only go to one of them. It cannot go to their dependents. And that is the most tricky part about joint ownership. You need to be absolutely sure that the other person that you hold title with is the only person that you want to benefit from this property before you're registered as joint owners. I hope that this broadcast has been helpful to you. I can imagine that there will be many questions. Please comment down below, and and please subscribe and share, and stay safe. God bless. Bye-bye. Hello and welcome to Legal Basics with Sairolawglobal, and my name is Sian. On this channel, we help you to demystify complicated legal concepts. So today we are going to talk about a tenancy in common. A tenancy in common is often confused for a joint ownership. However, for a tenancy in common, the amount or the share or the ratio that each person owns is indicated on the document of title. So let's go back to our situation. We have 2 people. These 2 people are working, they're good friends, they're in a chama, they are focused. They decide now we need to get a plot. The plot is going for 500,000. While each of them can raise 250,000, each on his own cannot find funding for one property on their own. So what do? They decide to both go and get the property. So now, if they don't intend to be joint owners, then the property is going to come out with both their names, indicating exactly how much of the property each owns. So in this case, if Peter and John go and get a property, Palengong, the property is going to come out with Peter 50%, John 50%. It could also indicate the ratio. It could also indicate the fraction, 1/2, 1/2. For instance, if 3 people get property, it could be a third. So now, what is the difference between a tenancy in common and a joint property? For a tenancy in common, it is it is possible to know exactly which ratio a person owns. For this reason, one person can buy the other out. For example, if Peter and John decide that they no longer want to be on the same title, Peter can pay John for half of the property and she can buy him out. In that case, the agreement, John will sell 0.5 of the property, Peter will sell 0.5 of the property to Joanne. Now, if one of them dies, the amount or the share that they own is going to go through the succession process to their estate, to their wife and their children and their mother and their father and all their dependents. So the difference between a tenancy in common and a joint ownership is that for a joint ownership, the property only devolves to the other named owner. In a tenancy in common, the share of property that is owned by every person is going to go to their dependents as opposed to the other joint owner. If the other joint owner is a dependent, yes, they could get a part of the property, but if they are not, then the property will go to their dependents. Now, how do you know that you're a tenant in common as opposed to a joint owner? A tenancy in common, which could be the safest way of holding property if you're not a married couple, will indicate the fraction or the percentage, or it will indicate the ratio of ownership. Now, this is a very short broadcast, but I am sure that this helps you to differentiate between a tenancy in common and a joint ownership. If you have any questions, please comment on the link below. We're going to answer your questions. In the meantime, stay safe, sanitize, stay alive. Blessings, subscribe, share. Bye-bye. Hello and welcome to Legal Basics with Sairolawglobal, and my name is Sian. Today we're going to talk about a very interesting topic and sometimes very emotive, that is buying property from the diaspora. You know, many people will go out of their countries, find a job elsewhere, make great sacrifices, cut their family ties, leave their friends behind, work 16 to 18 hours a day just to have a better life. We've all heard of those stories when people send money home and they're encouraged and people give them pictures and say, oh, you know, your 5-bedroom house is almost done. This is the kitchen. And you come after many, many, many years of labor to find that there's nothing at home. I mean, it's very, very, very sad. So how can you avoid such situations? First of all, always work with a legal expert. Who is a legal expert? A legal expert is, first of all, a person that went to school and probably got a law degree, but also it is a person that is registered under a professional organization with a current practicing certificate. In Kenya, it would be an advocate with a current practicing certificate for the year that you want to purchase property and for all the years that you're going to be engaging their services. So how does this help? A professional legal expert, first of all, will ensure that you know your rights, will ensure that you meet your obligations, but most of all, they're going to be tied by their professional undertaking, such that if anything goes wrong in this transaction, you can always go back to their organization and report them, and they can be deregistered if they dupe you, for example. You cannot compare that to your beloved brother who squanders your money, and when you come back home, maybe sometimes the only option available to you is to forgive them. Always work with a legal expert. Secondly, how can you get into agreements from the diaspora? So the first thing is you can get into agreements from the diaspora by having your documents shipped and then going to a notary public and signing them and sending them back to your lawyer, but that could be a very rigorous process. The second option you can have is you can register a company. Now, in the Kenyan law, recognizes a sole-owned company, which means that you from the diaspora can actually register a company in Kenya, and you would be the only owner of that company. After you register your company, then you can appoint directors who are on the ground. You can appoint your mother or your sister or whoever you trust, or your wife or your husband or your spouse. Now that ensures that the property is owned by your company, but somebody else is able to get into agreements and sign and execute for you. So execution means signing. I'm very sorry I keep using these legalese terms, but execution means signing. The third option you can have is before you leave the country, you can assign a power of attorney to a person that is trusted. And then after assigning that power of attorney, you need to register the power of attorney at the land's office. And then this person can enter into specific transactions for you. A power of attorney can be general. It can either assign a person to do everything on your behalf, or it can also assign specific things like dealing with a specific account or dealing with a specific transaction. So this ensures that the person that you've donated your power to can only act within your instructions, and you can have some kind of legal right over them. Now, after you've done that, do not ever get into any property transactions without a full due diligence. You can have either your lawyers do that for you, or you can have experts, for example, surveyors and all that. Thirdly, always have different people follow up on your projects. For example, if your family member is the one that is in charge of a building project, for example, it is good to assign different parts of that legal project to different people. One person could be the contractor, one person could be in charge of procurement. This is just to ensure that things are moving in your absence. I'm sure this video will bring a lot of questions. All your questions are welcome. Comment down below and subscribe and share. Stay safe. Bye-bye. Hello and welcome to Legal Basics with Sairolawglobal, and my name is Sian. This is part 2 of the 3-part series on due diligence. So now you've spotted the property that you want, you have carried out the search, you have done your investigation, you know that the property is at the price that you want to buy, it's legitimate, you've gone with your surveyor, you've seen that the actual piece of land that is being sold to you, or the house or the office, is the one that you want to buy. What is your next step? The next step is you must ensure that the parties that you're dealing with are legitimate. So now, if you're dealing with a natural person, a living, breathing human being, you must see their original identity card or the original document of identity. Some people don't have an identity card, maybe it got lost, they can use their passport, but you have to see the original document. And the reason is because some people can steal or even find copies of documentation for other people and use them in transactions, so you have to see the original ID. Secondly, you have to see their original PIN. Now, if you're dealing with a company, it is very, very extremely important for you to carry out a search on the company. What a search on the company is going to do, it's going to tell you whether the company is duly registered. It is going to tell you the directors in office. Remember, in our previous broadcast about an agreement for sale, we said that if the wrong directors to the company sign an agreement, then the agreement becomes invalid because they are not in office and they do not have the right power to transfer property. So after you know which directors are in office, after you know what is the registration number of the company, and after you know that you're dealing with actual persons, then you can proceed to do your agreement. When you proceed to do your agreement, make sure that both parties are represented by an advocate. If it is possible, let a different advocate represent the different parties to a transaction. Now, sometimes an agreement for sale includes third parties that are not the seller and they're not the buyer. Sometimes the agreement requires you to pay the person that helped you know about the property, sometimes the broker. If it is possible, make sure that you capture the details of this third party in your agreement, so that you do not have to go through situations where somebody else has the title documents, or somebody else is standing in the middle of your transaction. Again, when you do carry out a search, and sometimes you find that the property, the house or the office or the plot has been encumbered, if it has been given to a financial institution like a bank, ensure that this financial institution has given you a written consent to proceed with the transaction. Remember that a mere encumbrance is not a reason for a person not to pass property or to acquire it, but the details of that encumbrance have to be known to both parties and you have to agree with it. For example, if somebody has taken a loan against a property, they can still pass it on, but they must have the full consent of the financial institution that they have given their land or their office or their house to, whatever property it is. They must have a written consent from them, and you must be in a position to have agreed what will happen when you take over the property and the encumbrances. I hope this has been helpful. Part 3 of the series is coming, and it will deal with what to do after the agreement. I hope that you're going to write to us with all your questions. Comment down below. Stay safe, sanitize. Bye-bye. Hello and welcome to Legal Basics with Sairolawglobal, and my name is Tian. Today we discuss a topic that is talked about a lot but little understood, and that is due diligence. So what does a due diligence mean? It means that a person has found out enough information about a transaction to ensure that they're going to make the wisest, most informed decision. So when you're a buyer and you want to acquire property, you need to carry out due diligence all the time before you commit yourself to an agreement and before you fulfill any obligations. So what is the first thing that you need to do? You need to know the general information about the property that you want to acquire. For instance, how do you know about this property? It could have been through an advertisement, it could have been through a broker, it could have been through the radio, it could have been through the newspaper. So one thing you need to know is that whenever there's a broker in the middle, especially if it is an informal transaction, some people will try to make a big deal out of a sale. So we're living in the age of information. How do you save yourself? So first of all, you need to know something casual, general about this property, about its location, about its size, about who is selling. Just by a simple Google of what is the price of an eighth of an acre in Lithuania, you will be able to know the range, the price range. You will be able to know whether this particular place has issues. For example, the properties at Ngong Forest at the moment. You will be able to know whether this particular person that is dealing has had unscrupulous deals before. Those things are very important just at the beginning of a transaction. Secondly, you have to do a search. How do you do a search? Well, when you start the process and you have communicated to your to-be seller that you intend to acquire a property, they should be able to furnish you with a copy of the title and a copy of their PIN. Now, with a copy of the title and the PIN, you can be able to carry out a search. A search is very, very, very important because under our laws, a document of title is not the conclusive proof of ownership. The conclusive proof of ownership is the register that is kept at the lands office. Now, when you carry out a search, then the government is able to go through their register and they're able to tell you exactly who owns the property, whether the property is encumbered, whether it has been given for a loan, whether a caveat has been registered under it, and this is information that we would ordinarily not find out from a seller. Third, you have to carry out a survey. How is this done? The moment that you know the title number or the reference to the property that you want to acquire, through the same copy of title, you can go and get a map of the locality that this property exists in. Every property in Kenya that has been adjudicated has a map for the area. When you go to the land office, get the map. then go to a certified surveyor. Always deal with a professional. Have the surveyor go to the ground and tell you exactly which piece of land you are buying. We have found many people who are sold for a piece of property that is sometimes vacant, yet the one that is really referred to is another one that is owned by another person, sometimes even under construction. So this helps you to know exactly which property you're buying. This will be the end of today's broadcast. That forms part 1 on a 3-part series on due diligence. We hope to get your questions and we will respond to them. Please write to us on sairolawglobal@gmail.com and comment here below. Stay safe. Bye-bye. Hello and welcome to Legal Basics with Sairolawglobal, and my name is Sian. Today we are on part 3 of the 3-part series on due diligence. Na hii episode ni ile ya kukaa rada. So now you have seen your property, the one you want to buy, you've carried out a search, you've gone to the surveyor, you have checked out the parties, you're sure that if you're dealing with a company, you have the right directors. If you're dealing with a natural person, you're sure you're dealing with the person who's named on the title. And now you get into an agreement. What next? First of all, when you're already going through this agreement, ensure that you're paying, if you're the buyer, you're paying the least possible deposit. So at the negotiation stage, ensure that the amount of money that you give to this seller is the least possible that you can negotiate in that transaction. Why? Because things can go wrong and for some reason the property is not transferred to you. And you have to ensure that you don't lose too much money in the process. You see, at the end of the day, we hope that everybody comes to the table with goodwill, but the truth is that not everybody comes to the table with goodwill. Secondly, if your party is married, ensure that they have a spousal consent. And this would be in the form of an affidavit signed by the spouse of this person, saying that they do not have anything against this transaction. Remember, under our current land laws, a spouse can actually nullify a transaction. So this means that you can actually pay the entire purchase price and the spouse of this person can show up and say, I did not know, and sorry, I did not want this land to be sold, and it can be cancelled. Now, after you pay your deposit, ensure to take constructive possession. What does constructive possession mean? It does not necessarily mean that you start to develop a plot. It does not necessarily mean that you're going to move into a house, but it means that you need to do something to that property that only an owner could have done to it. For example, if you've bought a plot, you should start fencing, probably bring a lorry of sand, bring some cubes, have somebody live there. If it's a house, if it's an office, start painting. And the reason why it is extremely important to take constructive possession before you have finished a transaction is because it usually brings out issues that the seller could have conveniently forgotten in the process of sale. For instance, many families give property to one person who is believed to be the more responsible among the siblings or the most learned, the one who went to school. So for some reason, property is registered in their name. Most of these people are good, but some of them do want to do things that are not acceptable to the others, and they might have left out the fact that they're holding property in trust for somebody else. Sometimes property is truly registered in the name of the rightful owner, but there's a court case, the case is unreported, and you have no reason as a seller to know that actually this property is under a dispute that is ongoing in court, and sometimes it's not even in court, sometimes families are just feuding. So when you take constructive possession of property, it means that you're going to be doing something that is going to attract some attention to you as the new likely owner, even before the transaction is complete. So this helps you to be able to secure your interest, to really know that the property can be transferred to you, and to really know that then you're safe to complete the rest of your transaction. Now, when the property has been given out as a security in a financial transaction, you also need to know that the loan the loan that the property was supposed to secure is either being paid, or it is an amount that you as the buyer can clear with the amount that you're supposed to pay as exchange for this property. Because sometimes people get into financial transactions and then they default, and then the loan grows and grows and grows way beyond the amount of money that you would have been willing to pay as a buyer for the property. So I hope you as a buyer utakaa rada, usiibiwe pesa, and I really hope that to see you next time. Subscribe if you have any questions. Reach us through our Gmail address, which is sairolawglobal@gmail.com. Sanitize, stay safe. Bye-bye. Hello and welcome to Legal Basics with Sairolawglobal, and my name is Sian. Today we're going to talk about holding of property under a company as opposed to holding it under an individual. In our previous broadcast, we mentioned that the current company's law in Kenya allows for a sole-owned company. So that means that a person can register a company under their name, where they are the shareholder, who also doubles up as a director. However, legally, these two positions are distinct and separate. Also, in a previous broadcast, we have suggested that people who live in the diaspora do have the option of buying a company, of registering a company, and then appointing a local director who can then enter transactions for them. So that is the first advantage of a company. The fact that you can have a director who contracts on your behalf if for some reason you're not able to contract. Secondly, human beings are all going to die. This is a reality of life. However, companies last forever. Because of this very unique characteristic of a company, when you create a company, you sort of create a legal clone that is going to outlive you. So when you create a company, you've created an entity that can hold property way after you are not here. You're no longer here. Third, a company is a very separate legal person from the owner. For instance, Paul is separate from Paul Limited. So when Paul registers Paul Limited, the property held under Paul Limited is not going to be touched by the dealings that Paul is going to enter as a person. One of those dealings is marriage. Remember, under our current marriage laws, if a person gets married and their spouse gets to improve or carry out anything on the property that they already owned before the marriage, then they acquire a stake. However, property owned under a company is not subject to matrimonial causes, because the person and the company owned by a person have two separate, distinct legal entities. So this is one way that people can insulate themselves and the properties that they have from marriages. And we're living in unprecedented times where people get into probably one or two or three or more marriages in their lifetime. And some of those stories are very tragic, where people get one spouse, they improve this property, they divorce, the spouse has to get half of that property, then they get another spouse. So having a property under a company is also another way to insulate it. Now, a company or holding property under a company also ensures that there's some form of continuity when a person dies and when their dependents have to go through the process of succession. Because as we said, a company is a separate legal entity. For instance, if a person over the years has accumulated lots of properties and a company, and this person dies, the directors of the company can carry on managing this property before the succession process has gone through. So, for example, in the event of a succession, only the shares of the company will move. The directorship will not. So eventually the shareholders could change the directors in office, but if they don't, the directors at the point of maybe the owner passing away will still carry on management exactly the same way that it was when a person was alive. I hope that this broadcast has been helpful. I imagine there will be many questions. Please reach us on our email address, sairolawglobal@gmail.com, or comment here below. We are going to answer all your questions. Thank you for staying tuned. Protect yourself, protect your family, and God bless. Bye-bye. Hello and welcome to Legal Basics with Sairolawglobal, and my name is Sian. Last week we wrapped the series on property acquisition, and today we're back with a very interesting series on the law of business associations. Now, since the corona pandemic, many people have been discussing a side hustle. Many people are thinking now that maybe it's not very safe to rely on only one source of income, whether that source of income is employment or just one business, because then it is exposed to the happenings of life like this pandemic. Again, many people are in business, but they do not think of themselves as business people. Some people teach an instrument, some people fix other people's computers, some people are creative, they make hair, they make clothes, they make accessories, but they don't think of this hustle as a business. Now today we're going to be discussing sole proprietorship. And this is a business that is run by one person. So many people will consider to be a sole proprietor for many reasons. First of all, it is the easiest business to wake up and do, because all you need is yourself, your ideas, and your resources. You do not need somebody else to be in the same place with you, either in terms of capital, in terms of labor, or in terms of availability. So generally, they're very easy to set up. But what are the legals of the sole proprietorship? First of all, if you're a sole proprietor, it means that you and your business are the same legal person. So if you own a shop, for example, everything in that shop belongs to you as a person. If you get into debt and you cannot settle that debt, then your personal property can be applied in settling of that debt. That situation will be defined as an unlimited liability, which means that when your business gets into liabilities, then you're still personally liable. Whether or not you have registered your business, whatever the business gets into, whether it's a legal situation like a contract, then the owner of the business will be personally liable for the obligations under that contract. Again, if the business is sued, a sole proprietorship will have the business sued in the name of the owner. So most of the time you will see legal documents have either the plaintiff or the defendant as XXX trading as Njoroge trading as Sunfarm Industries. This means that the business is not a separate legal person from the owner. Now, in the event that, for example, in that same court situation, the court finds the business liable for 3 million and the business cannot raise 3 million, then the owner himself has to raise that money because the liability of the business is unlimited. Now, a sole proprietorship brings the greatest challenge in terms of raising of capital, in terms of succession, and most importantly, in terms of investment, because everything in the business belongs to the owner. So when you do take in a partner or an investor, or when you want to expand your business, it presents a challenge because the business items and property are the property of the owner. So when the investor comes in, there is no part of the business that can be sold to the investor unless they decide to coast it and then transfer the ownership of that property. So in essence, there is no business entity. Still, a sole proprietorship is a good way to start, because as we said in the beginning, all you need to do is your own motivation, your own capital, your own know-how. It is easy to start. And at the beginning, before you can find somebody else who shares your dream, it is actually encouraged that you can register your business and start to work. Again, it is important, even as a sole proprietor, to think of your business separately from you. As we said, many proprietors will be doing something on the side, but they don't really think about it like a business. Maybe you teach piano, maybe you make people's hair, maybe you make earrings, but until the day that you think of your business separately from you is when you will start to do your separate documentation, you will start to do your separate planning for your business and for yourself, which is important when you want to get organized. Now, I hope this broadcast was useful to you. We expect your questions. Please write to us at Sairolawglobal@gmail.com. See you next time. Sanitize, stay alive. Bye-bye. Hello and welcome to Legal Basics with Sairolawglobal, and my name is Sian. Today we're going to talk about partnerships. Partnerships are pretty common, and some people do it well, some people don't do it well, and that's the reason why most partnerships do not survive in the long haul. Now, what to do at the beginning of a partnership? Before you start a business with another person or another group of people, you need to be clear about why you want to start a business with them. The reason why most partnerships are not making it in the long run is because people assume that all you need from other people is capital. And that is not true. Yes, you need capital, but also you need to be equally yoked in terms of know-how, in terms of your integrity, in terms of your industry. How hardworking are all of you? Now, what is the legal status of a partnership? Just like a sole proprietorship, partnerships are not distinctly different from their owners, which means that if person X, person Y, and person Z start a business, everything in that business is associated with them. If, for example, that business gets into a contract, then the partners have to sign because it ties them personally. If the business is sued, then the partners are also sued as owners of the business because the business does not have a separate legal entity. Now, to avoid all the issues of partnership, to avoid the issues of one person working and the other one does not work, to avoid the issues of one person having integrity and the other person deciding to play around with the property of the business and maybe the client's goodwill, before you start a partnership, establish that you're equally yoked with your partners and that your visions are aligned. After that, ensure that you have a partnership deed or a partnership agreement. So what is the content of a partnership agreement? First of all, it says who are the partners, when the partnership started, what exactly the business does. After that, it apportions responsibility. When people start a business, sometimes they don't have the same strengths. One person is a good administrator, the other person is a good marketer, the other person is better at execution. So if this is the reason why you come together, then it is important that you, as the partners, put it down. What is each person's responsibility? Again, a partnership agreement will deal with issues of money, which are very, very serious. So it deals with issues of capital, how much each person has contributed to a partnership. It deals with issues of drawings, how much can the partners take. It deals with issues of how much can be plowed back. It deals with issues of whether the partners are going to take a salary or not. It also deals with issues of expansion, how to take in a new partner. So it's very important to have a partnership deed because at the beginning, most businesses are small and most issues look very light. But as the business grows bigger and bigger, then the issues start to come up and there's likely to be disagreement. Again, in a partnership deed, also deal with how you would like to resolve your issues. Of course, it is shameful for people to start well when they're when their businesses are small, and when the business grows big, then they're all over in court. It's not organized, it's not nice. So a partnership deed, one of the things it can do is it can say how disputes are going to be resolved along this way, and it is advisable that the partners prefer to go for alternative dispute resolution methods before they decide to go to court. Again, a partnership deed will also deal with stuff like accounts, signatories, who is to get into agreements for what. Some of these issues are extremely important as you go on. Now, again, a regular partnership does not have limited liability, which means whatever any partner or employee of the business does eventually ties the other partners because they're not separate from the business. So again, when a partnership wants to expand and maybe take in an investor or take in a partner, it is very good that the process of taking in that new partner be dealt with in the partnership deed. Again, the partnership deed can also lay out how partners are to agree on issues. Especially when you have a bigger number of partners, then maybe they will never be on the same page on most issues. However, decisions must be made. So when you have a partnership agreement, it helps you to agree on how are you going to make major and minor decisions. Some minor decisions might be made by the partner in charge of that department. However, major decisions will need the partners to have a serious way that they decide whether something is acceptable and whether it's not. So a partnership agreement is going to set those thresholds. Some decisions will need consensus, that is where all the parties agree. Some decisions will need a simple majority. That's where if you have 3 partners, 2 decide to go with the decision and 1 doesn't, then 2 win the day. It could also incorporate percentages of shareholding. Again, partnerships do not have to be equal. For example, 2 partners do not necessarily have to own 50% of the business. 3 partners do not necessarily have to own a third of the business. A partner can own 70% while other partners own 10% each. Some partners can own 25 while another owns 50. So of course, when people put their money somewhere, they expect that the money will speak for them. The partnership agreement can also set certain decisions based on the percentage of the business that each partner owns. Now, I know this broadcast will also bring many questions. Please write to us at sairolawglobal@gmail.com. We will be happy to answer your queries. Thank you for staying tuned. Sanitize, stay safe, protect your families, and God bless. Bye-bye. Hello and welcome to Legal Basics with Sairolawglobal. Today we discuss a form of business organization that is quite new, little known, and little understood. And this is the limited liability partnership. Remember, in our last broadcast, we dealt with partnership and we explained that in a regular partnership, the partners do not have any limited liability, meaning that their liability is unlimited. The actions of a partner will tie the other partners. However, in a limited liability partnership, it combines the benefits of a partnership and the benefits of a limited liability company. However, it is not a company. So let's start with the first feature of a limited liability partnership. Like a regular partnership, the actions of the partners will tie the specific partner that has gotten into that liability. For example, if let's say we have 2 architects and they run a business called X and Y Architects, and this business is a limited liability partners, and one of the architects builds a house and the house sinks during the rainy season, and they're taken to court and the court finds him liable. Now, the action of that partner will not tie the other partner. So in a limited liability partnership, a person does not tie the others. However, in a regular partnership, then the other partners would have to be liable. Secondly, in a limited liability partnership, the partners, just like a regular partnership, are involved in the day-to-day running of the business. Remember that in a company, shareholders and directors have different legal responsibilities. Shareholders own the company, directors run the company. But in a limited liability partnership, the partners are the owners and also they take part in the day-to-day running of the partnership. For this reason, it is important that people who want to get into a partnership, especially if it regards a professional service, get into a limited liability partnership as opposed to a regular partnership. Because if a doctor gets into a case of medical negligence, for instance, then he ties himself, he does not tie the other doctor in that partnership. But in a regular partnership, he will tie all the others. Now, our limited liability partnership has some of the benefits of a company because it has corporate status. What does corporate status mean? It means that the business has a separate legal entity from its owners. So, a limited liability partnership will be sued. It can sue on its own. It can own property. Now, this is a very beneficial feature to the limited liability partnership because it ensures that if the business gets into liabilities that overwhelm it, now it cannot impact personally on the partners. Again, it allows the limited liability partnership to get into contracts on its own. For instance, if you're in a regular partnership and you want to get some floor space, X and Y partners will have to sign the tenancy agreement of that office, as in their legal capacity as X and Y. However, in an LLP or a limited liability partnership, because the business entity is a separate legal entity, then the LLP is the one that is going to contract and sign the lease agreement for office space. Now, for people that are getting into partnerships that regard professional services, a limited liability partnership is more suited than a regular partnership because, again, a corporate status ensures that the business entity outlives the partner. If one partner leaves, the business entity can still continue just like a company. If one partner dies, the business entity can still stand. However, for a limited liability partnership, you must have a minimum of 2 partners. Remember, for a company situation, especially in Kenya, you can have 1 shareholder. But now, for a limited liability partnership, the minimum number of partners is 2. So you can have a bigger number. Some jurisdictions limit the number of partners that you can have in the limited liability partnership. But the number can never go below 2, which means if there's only 2 people and 1 dies, if 1 is not replaced, then the business entity cannot stand. I hope that this broadcast has been useful to you. Please write to us with your queries at sairolawglobal@gmail.com. Thank you for staying tuned. Thank you. Sanitize. Have a good night. Hello and welcome to Legal Basics with Sairolawglobal, and my name is Sian. Today we discuss a form of business organization that is a company. So what are the features of a company? First, a company has limited liability. Secondly, a company has perpetual succession. This means that even when the owners of a company die, the company itself remains intact. Thirdly, the company has corporate status. Corporate status means that a company is a separate legal entity from its owners. So that means that the company can enter into contracts, it can sue, it can be sued. Now, at the point of registration of a company, two documents are very critical. That is the memorandum and the articles of association. The memorandum deals with the relationship between the company and the outside. For instance, it will specify what services a company offers. It will specify what goods a company supplies. It will specify how a company can be taken over, whether it can borrow, whether it can sell or own property. Generally, how this company interacts with the world outside of it. Now, the articles of association, on the other hand, specify how the internal issues of the company will be handled. For instance, for companies that are owned by families, the articles of association can limit who can be a shareholder in that company. It can specify that certain biological children or siblings are the only people that qualify to be shareholders in that company, and in that case, the shares can never be transferred to strangers. Under the articles of association also, decision-making is handled, how are decisions arrived at. In our previous broadcast under general partnership, we explained that under a partnership deed, how decisions are arrived at need to be specified. The same thing happens when you come to a company. Under the articles of association, the mode of decision making is explained. How big decisions or major decisions and minor decisions are to be made. Minor decisions may be made by directors, major decisions may be made by shareholders, but even at that level, it specifies which percentage, whether a decision needs a general consensus, whether a decision needs a simple majority, whether a decision needs certain amount of shareholding to support it for it to fly. Now, remember, because a company is a separate legal entity from its owners, it means that the liabilities of the liabilities of the company do not affect the owners. However, remember, limited liability does not mean that shareholders do not have liability. It simply means that their liability is limited. For example, let's say that a company has been formed with 100 shares and each share is worth 1,000 shillings. So the nominal share capital for that company is 100,000. Now, if let's say person X owns 10 shares, that means the value of his shares is 10,000. If this company gets into liability that overwhelms it, for example, it gets into debt, it gets into a loan and then it defaults and it cannot pay, or maybe there's a judgment against the company that it has to satisfy, and the assets of the company are not enough to satisfy it, then the owners of the company will be liable up to the level of their shareholding. So this means that if I own 100 shares and each share is worth 1,000 bob, then in case the company cannot satisfy its liabilities, I am liable up to the tune of 10,000 bob. That is exactly what limited liability means. It does not mean that you're not liable. It only means that you're liable up to the tune of your shareholding. I hope today's broadcast has been helpful. Please reach out to us with your queries. Please email us at sairolawglobal@gmail.com. Sanitize, stay safe. Bye-bye. Hello and welcome to Legal Basics with Sairolawglobal, and my name is Sian. Today we're going to talk about the basic operations of a company. So, a company works a lot like a bus. So let's say we have a bus that is a 64-seater, and then we have a driver, we have a co-driver, then we have a conductor, and then we have people that are seated down. Now, Just like a bus driver, the directors of a company are the ones that decide where the bus will go. For example, you'll find that most of us have bought shares in big companies like maybe Safaricom, maybe Kengen. However, when they make decisions, they don't call us, right? Because we're the shareholders, but it is the duty of directors to make everyday decisions, just like a bus driver. So when that bus is on the road and the bus driver sees a stone, he's not going to turn and ask the passengers, do I swerve or not? He's going to swerve. And then after swerving, he's going to tell the passengers, well, there was a stone and that's why we had to go to the left and then to the right. That's exactly how directors work, because they're the drivers of the company. However, before the bus started this trip, it is the passengers that decided that we want to take a trip to Malindi, or we want to take a trip to Tanzania. Same way, the biggest decisions of a company are made by the shareholders, although they empower the directors to make the day-to-day businesses of the company. Now, the big decisions that are made by the shareholders will usually be made at the AGM, which is the annual general meeting. If you have attended any AGM of any of the companies that you own shares to, you will see that the members, the shareholders, have to take a vote on the big decisions. And the big decisions could include who should be a director or not. Just like our passengers to a trip will decide who should be the driver and who shouldn't. Now, in this same bus, there is a conductor. The conductor will take instructions from the driver once in a while. The driver will say, okay, give the people water. And the conductor will take a box and give people water. And then if there's something that the people want to communicate, they will use the conductor to say, tell the driver, we need to take we need to take a leak, or we need to take a walk, or we need to take pictures. You see, just like the way a conductor takes instructions from the driver, is the same way that directors will be in charge of the managers, and then the managers will be in charge of the departments. That is in a big scenario of a company. However, in the very small aspects of a company where people have just decided to register maybe a company for their small business or for their family, and sometimes when the shareholders double up as directors, it means they have to make the big decisions where the company is going, what the company will do, and then they also have to make the everyday to-day decisions, just like a driver. I hope today's broadcast has been interesting and it has helped you to understand the different roles between the shareholders, the directors, and the management. Please write to us with your questions and your queries at sairolawglobal@gmail.com, and we'll be happy to answer you. Sanitize, protect your loved ones, and see you next time. Bye-bye. Hello and welcome to Legal Basics with Sairolawglobal, and my name is Sian. On this series on business associations, today we discuss whether or not it is beneficial to register your business. Again, we said your business could be in the form of a sole proprietorship, it could be a normal partnership, it could be a limited liability partnership, or it could be a company. Well, for limited liability partnerships and for companies, the business must be registered to be a company or a limited liability partnership. A business cannot be either of those two if it is not registered. However, for a sole proprietorship and for a normal or general partnership, the business does not need to be registered. However, what are some of the advantages of registering your business? First of all, when you register your business, you get to think about it separately from yourself. You get to be more organized. You get to separate what belongs to the business and what belongs to you personally. It helps you to get organized. Secondly, You can always open a bank account in the name of your business, even if legally that business is not a separate entity from yourself. We all know that a person who steals from their business, eventually the business does not grow. So for you to thrive in business, you have to be able to separate your finances and the finances of the business so that you know whether you're making profits, whether you're making losses, whether you're paying yourself, whether the business is growing, whether anything needs to be amended. Thirdly, most people imagine that if you do not register your business, then you do not pay tax. And this is not true. Well, some people running very small enterprises may escape payment of tax. Still, the fact that you're in business and you're not registered does not exempt you from paying tax. Everybody who is in business needs to pay their fair share of tax, whether you're registered or whether you're not. Okay? Fourthly, now registration of a business keeps other people from registering a business in the same name. When people are registering a business, they have to give at least 3 options of a business name before the business is registered. The reason is because the registry of businesses will look and check whether there's other businesses going by the same name. If any other business has been registered under that name, then you cannot register. And this is very important for people who are beginners. For example, let's say Susie, which is a name that is well known, starts a baking business. And Susie is very good. She has a very nice banana cake. She has wonderful cookies. She has a blueberry cake that nobody else can make in her town. And she decides to name her business Susie Yummies. And while she's baking in the house and taking orders, her business grows and she enrolls somebody else. She calls Mary and says, "Let me pay you a little money for you to help me with baking of cakes." So Mary works for Susie for a while and Susie shares her trade secrets, exactly how many teaspoons of sugar she adds, exactly how much butter, so that her cakes are special. But something happens between Susie and Mary is fired. However, Mary goes and starts to do the same thing she was doing at Susie's. She gets an oven, she gets her ingredients and starts to cook. And now some of the customers who used to call Mary while she worked for Susie still call Mary and says, "Hi, do you have the blueberry cake from Susie Yummies?" And Mary says, "Yes, and I'll just send some M-Pesa and I will deliver." Can Susie stop Mary from taking her customers or using her business name? Probably not. Now, what if Mary goes and registers Susie Yummies? Will Susie come and say, "Well, you know that name was mine"? If Susie had not registered it, then Mary will be able to use the name in business. So when a person registers their business, it stops any other person from registering that same business name. Fifth, when you register a business, you get the opportunity to build your brand. Building your brand will take a lot of work. It will take you bringing unique products to the market. It will take you having wonderful customer service. It will take you having to even sometimes invent or design new things, and these things will be continuously related or associated with the business name that you give your business. However, you need to know that a business name is not a trademark. If Susie Yummies is a business name and it has been registered, other people may not be able to register another business by the name Susie Yummies. However, if Susie has not protected Susie Yummy under a trademark, then that trademark could be available for registration by somebody else in the same line. On our next broadcast, we are going to explain the several forms of intellectual property that business can protect. That will be it for today. Sanitize, stay safe, Take care of your loved ones. Bye-bye. Hello and welcome to Legal Basics with Sairolawglobal, and my name is Sian. Today we're going to go through the checklist that you need to register a business. First of all, you need to have decided on your business name. And because sometimes you're not sure whether the name that you want is available, whether somebody else has registered a name like your business or a name that has very similar aspects like your business, you need to have at least 3 or 4 options, so that if the first one or the second one is not available, then you have 2 others that can be considered. It is also advisable that you go for business names that are as unique as possible, because you can imagine how many other people register businesses in a name that you would be attracted to. Secondly, you need the identification details of all the business owners. It could be an identification card. In some circumstances, it could be a passport. Now, for a sole proprietorship, for a partnership, for a limited liability partnership, all you will need is the identification details of the owners. However, for a company, the owners, who are the shareholders, may also want a different set of directors. Sometimes shareholders in companies double up as directors, but sometimes shareholders want other people to act as directors. In the event that shareholders prefer another set of directors, then they also have to include the identification details of those directors. Third, you should have the personal identification number certificate, or the PIN, what we classically call the PIN. The PIN is important because it is the document that is attached to business owners' tax details. After you have that, you need a business premise. Usually, as far as a premise goes, you will need to provide the details of the building, of the floor number, sometimes of the street, and of the town. And although some businesses start off without really having a premise, it is important to have a premise that can receive your correspondence, any notices that are sent to your business, any letters or deliveries, a place that these things can be delivered and they can get to you. So it is important to make arrangements for such a premise before you decide to register your business. Fifth, you must have a full description of what your business is about. This will include what your business does, what it deals in, which industry. You need to be very clear about these things before you decide to register. Now, for businesses that deal with professional services, for example, doctors, lawyers, they will have to provide the certification from the bodies that regulate them. So this will be on a case-by-case basis, depending with which business a person wants to register. Remember, a lawyer who registers a business that deals in law will have to give their legal documents that show that they are certified and that they're not going through a disciplinary process or something. But that same lawyer may not need to provide the same documents if he registers a business that is in an unspecialized field. So what the business does is what will determine the exact documentation that will be asked for. Now, if you're registering a business in Kenya, then all these things have been made easier through the eCitizen platform. The eCitizen platform serves Kenyan citizens and also non-Kenyan citizens who are resident in the country. If you do want to register your own business for yourself, then you might need to set up an eCitizen account where they will need your email and your identification details. However, you can always have your business registered by your agent or a lawyer. And when a lawyer registers a business for you, they can use their own account. However, you will still have to provide the documents on the checklist. Now, again, all the documents on the checklist, because the Kenyan system is online, you need to have the you need to have the soft document. For example, for your ID, it is not enough to have a copy of your ID. You will need to have a scan of your ID. And then you will also need a scan of your PIN, and you will need a scan of your clear passport photo. I hope that this broadcast has been useful to you. Please reach out to us for any questions that you have. Write to us at sairolawglobal@gmail.com. Stay safe. Take care of your loved ones. Bye-bye. Hello and welcome to Legal Basics with Sairolawglobal, and my name is Sian. Today we are going to talk about how to keep your business out of trouble. Number one, if your business is registered, ensure that all your records are up to date. If your business is a company, make sure you file your annual returns in time. If your business is regulated under anybody or any organization or any association that requires you to file any periodic paperwork, ensure that that paperwork is filed in good time to escape penalties. Secondly, if your business is under a body that requires any of the owners or the people operating under your business to be certified, ensure that their certificates are up to date. For people that belong to professional organizations, this might require them to attend periodic training. If it's possible, let your business pay for this training so that people that work under the business are always up to date with their paperwork. Thirdly, have very clear contracts. Sometimes a business is doing its best, but just because the contracts are not clear or the communication with their customers, they end up getting bad reviews. For instance, if you're in a business that offers products and services that need you to go to where the customer is, ensure that when you communicate with your customer, you agree on timelines, you agree on price, you agree on any factors that may make you charge a higher price, because these are the things that make your business get bad reviews, which in turn affects your credibility and it affects your brand. Third, data protection. Now, depending with whatever jurisdiction that your business exists in or the country, you might have data protection laws or you might not. Whether or not you have data protection laws, you need to keep yourself up to date with the things that are happening in the world. Today, businesses collect a lot of data on their clients. Now, you need to ensure that the data that you collect on clients is protected. Whoever works for your business, ensure that you train them on their duty to confidentiality, because it would be very wrong for you to employ people that take data or information and then they broadcast it. It would expose your business to lawsuits. Third, you need to ensure that you're having the correct contracts with your employees. A lot of businesses are stuck in the employment court. They are sued day in, day out because they do their things wrongly. When you do employ people to work for your business, you need to ascertain which laws apply to them. If they are contract workers, then you need contracts that specify the time and the obligations that the business has towards these people, and exactly at which point the relationship between the business and the employee will be severed. If your business employs casual workers, remember, just calling an arrangement a casual employment is not what determines whether it's a casual employment. So you need to know exactly which laws apply to casual employees, whether the arrangement that you have with your casual employee actually makes them a casual laborer or a permanent worker. Now, when you do have permanent workers under your business, ensure that you have the right contracts and that the business is meeting its statutory obligations. For instance, if a business operates in Kenya, it is the obligation of the business to pay tax on behalf of the employees. It is also the business's obligation to pay their national hospital insurance contributions and their NSSF, which is their retirement contributions. So at all times, ensure that your documentation is proper, that your contracts are clear, that you're protecting the data collected from your clients, and that the business is on its obligation with its employees. I hope that this has been helpful. We're going to have other broadcasts to expound on the concepts that we have introduced on this broadcast. Please take care of your families. Write to us at Sairolawglobal@gmail.com. Bye-bye.